My name is Eric Glitzenstein. I am the Director of Litigation for the Center for Biological Diversity, a national conservation and biodiversity protection organization. I'm also a lecturer in law at Harvard Law School, where I teach a seminar in wildlife law. Today, I'm going to talk about wildlife law. I'm going to focus on several of the major federal statutes addressing wildlife protection: the Endangered Species Act, the Migratory Bird Treaty Act, and the Mammal Protection Act, and also provide some background on how these laws came into being and the constitutional underpinnings of federal wildlife regulation in the United States. For purpose of today's discussion, I'm going to be focusing on wildlife as it pertains to animals and non-domesticated animals, animals that actually exist in the wild. In terms of law, what do we mean by law? What kinds of legal apparatus are we referring to? Well, actually, wildlife and human interaction with wildlife can arise on almost every level of government: local government, state government, federal government, international regulation of wildlife. I'm going to be focusing mainly today on how wildlife law in this country evolved from a state regulation to a huge federal role in wildlife regulation. And in order to understand all of that, it's really critical to appreciate that for most of the country's history, wildlife was really regulated almost exclusively by state governments. Sometimes at the local level, but state governments really had the ultimate legal power over wildlife in this country. And that became very important in an early Supreme Court case called Geer versus Connecticut, an 1895 decision in which the question was whether or not Connecticut could adopt a statute that prevented people from taking wildlife within the state of Connecticut and taking it outside the state. Wildlife that would be killed or hunted in the state was prevented from being transported across state boundaries. And the question before the Supreme Court was the constitutionality of that statute, whether Connecticut could prevent citizens either within Connecticut or citizens from other states from taking wildlife across state boundaries. In order to resolve that question, the Supreme Court majority addressed two issues. The first issue was what kind of power states had over wildlife. And the Supreme Court went through this very expansive, comprehensive, historical view of wildlife and human relationship to wildlife, and how governmental entities could have some role in wildlife conservation, and went back all the way to Roman law, went through British Empire and the monarch's assertion of sovereignty over wildlife, and basically found that this was a fundamental kind of role that government would have. It was to protect wildlife, but also to regulate wildlife for the purpose of the benefit of all of citizens of the state. And essentially, the Supreme Court said that this kind of sovereign authority over wildlife would extend up until the time of the states becoming colonies of Great Britain, and then when they became states within the United States. And essentially viewed that role as one of not only a power, but also an obligation to assert authority over wildlife, not for the benefit of the sovereign, the governmental entity, but for the benefit of all of the people, essentially a trust responsibility. So that was a very important aspect of the Supreme Court's analysis that continues to resonate today. The second part of the decision has not stood the test of time as much, and that was whether or not the state could adopt a provision that essentially prevented wildlife and animals from being transported across state lines with no constitutional implications. And in that respect, the Supreme Court decided that the Commerce Clause in the Constitution, in Article 1, Section 8 of the Constitution, was not violated, even though it gives Congress the ultimate authority to oversee interstate commerce, and relying on a pretty technical kind of analysis, saying, well, since the state law doesn't allow wildlife to go across state lines, it only deals with intrastate commerce, not really getting to the heart of the question, which was whether or not the prevention, the inhibition of interstate commerce was a violation of the structure of the Constitution and the Commerce Clause. Important dissenting votes from two Supreme Court justices, Justices Field and Justice John Marshall Harlan. And Harlan is actually very well known in legal history as the great dissenter. He wrote the dissent in Plessy versus Ferguson, among many other high-profile historic Supreme Court cases. And they wrote decisions that basically agreed with the majority about the state having this important role to protect wildlife, but also said that that role could not actually come into conflict with the Congressional Commerce Clause power. That when the states started to prevent wildlife from moving across state lines, and did so for reasons that clearly seemed to be protectionist. That is, simply disallowing animals or wildlife to move in interstate commerce, then you are implicating an important constitutional limitation on state authority. So that was an important Supreme Court decision, which at that time really just ratified this notion that the states, as opposed to the federal government, were going to be the preeminent regulator of wildlife. And that actually helps to explain why the very first federal sort of fledgling wildlife protection statute in the year 1900, the Lacey Act, really built upon state law as opposed to acting in any contravention of state law. And in that statute, Congress, concerned about impacts on migratory bird populations, we'll talk about that more in a bit, adopted a statute which essentially made it illegal, a federal offense, for citizens of the United States to transport across state lines wildlife that was taken in violation of state law. So really kind of empowering states more than acting in derogation of state authority. And that Lacey Act, although it had very narrow kind of focus at the outset, continues to be an important wildlife protection statute. It's expanded over the course of time. So now it makes it a separate federal offense, a criminal offense, not only to violate a state law and take the wildlife across state lines, but also to violate other federal laws, including some of the other statutes we're going to be talking about today, the Migratory Bird Treaty Act, Endangered Species Act. Lacey Act has actually continued to play an important role in high-profile prosecutions. Many people watch the TV series about Joe Exotic, otherwise known as the Tiger King, who engaged in a series of nefarious kinds of conduct in connection with his maintaining tigers and lions at his facility. And he was charged with a whole series of federal offenses and has gone to prison for them, attempted murder, things that people have obviously paid attention to. But one of the things that Joe Exotic was charged with was a violation of the Lacey Act because he had maintained his tigers and lions in ways that violated the Endangered Species Act. And he also committed fraud within the meaning of federal statutes by basically conveying to people misleading information about how the animals were treated and what they would be used for in interstate commerce. So the Lacey Act continues to be an extremely important statute, but it had its origins back in 1900 when Congress was taking its first very initial steps towards implementing federal wildlife protection law. So how do we go from the Lacey Act in 1900, a statute that was very limited in scope based upon a Supreme Court ruling, which really provided enormous power to the states and a very limited role, at least a sort of sense of the limited role of the federal government and the federal constitution, to where we are today, with very expansive federal wildlife law, statutes which broadly protect certain categories of wildlife, and in which the federal government really can take a paramount role when it chooses to do so. To understand that evolution, three Supreme Court cases become critical to focus on. The first of which is a case called Missouri versus Holland, 1920 decision in which the court addressed the constitutionality of the Migratory Bird Treaty Act. Now, we're going to talk more about the MBTA in a bit, but it's important to understand the Migratory Bird Treaty Act was a domestic statute designed to implement a treaty between the United States and Great Britain, at that time acting on behalf of Canada, which was really the first time the U.S. government had entered into an international agreement to protect the wildlife resource, in this case, migratory birds, and had done so against the backdrop of plummeting bird populations, a concern that what was in place was simply not going to be adequate to protect birds from overhunting and other kinds of impacts on bird conservation. And so this treaty had been entered into, and then Congress had passed legislation implementing the treaty domestically. And that statute was challenged by Missouri, which argued, relying upon Geer and other cases, that, wait a second, you can't come in and tell the state how it's going to regulate a wildlife resource. You can't tell us that we can't allow the kinds of hunting of migratory birds that we want to engage in. And so the Supreme Court had to address that argument. And the way in which the court did so, in an opinion written by Justice Oliver Wendell Holmes, was by relying upon not the Commerce Clause, which would have been very problematic after Geer, but rather the treaty power in the Constitution. And the treaty power in the Constitution is actually a dual constitutional authority. The president has the right to enter into treaties, and Congress has to ratify those treaties. And here, both of those things had happened. And so Justice Holmes said that the treaty was certainly an authority that could be implemented by the federal government. If that's the case, and we need to be able to implement the treaty commitments, then that has to be able to be also a basis for constitutionality for the statute implementing the treaty. So Justice Holmes relied upon the treaty power in the Constitution, could avoid the Commerce Clause problem at that time by saying that was the basis for federal authority over migratory birds. And in doing so, Justice Holmes issued an opinion which had very broad recognition of the right of the federal government to address what Justice Holmes characterized as national interests. And Justice Holmes, as an interesting historical anecdote, was a captain in the Civil War, had seen the horrors of the Civil War, and came out of that war with a very strong belief that the federal government had to protect and promote national interests. And that was a way of keeping the country unified and together. And he made statements that actually harkened back to his experience, where he said, we've seen what happens when the country gets too decentralized, when things just fall apart. And this is an example of how we have to assert constitutional interests, and then refers to migratory bird conservation as an interest, a national interest of very nearly the first magnitude. Doesn't go into a lot of detail about why, but it's a rather stirring acknowledgement that protecting wildlife is not only just a national interest, but one of very nearly the first magnitude, which then becomes extremely important in later cases addressing the federal role in wildlife conservation. Now, again, he doesn't say that states can't play a role, but he says that when the federal government is asserting this power, then the federal government has this interest. And it basically says we can't really count on the states when we have a migratory resource like this one to effectively protect migratory birds. So that's an important very first step down this path. The next important step is in 1976 with a case called Kleppe versus New Mexico. And in that case, the court was addressing the constitutionality of the Wild Horse and Burros Act, a statute that Congress had passed in recognition of the almost emotional place that wild horses have in the lore of the country. And the Congress had talked about how we had this great resource that really brings back the notions of the American West, and was designed to protect not only the populations of wild horses, but to address what Congress saw as real maltreatment, real abuse of wild horses. Interesting note about that statute, not only a conservation law, but really one of the first times ever that Congress had stepped in to pass a law designed to address abuse, maltreatment of animals, and recognizing that as a national interest. But that statute was also challenged, not surprisingly, again, by a state. The state of New Mexico came in and said that this federal law really was infringing upon state right to regulate wildlife. And in the decision that was issued unanimously and authored by Justice Marshall, Thurgood Marshall, the Supreme Court relied on a different provision of the Constitution, the Property Clause of the Constitution, which once again is very broadly written and says that Congress shall have the power to establish all needful rules and regulations over the federal lands. And Justice Marshall said that this meant that Congress could establish the rules and regulations not only over how the lands themselves would be treated, but it also allowed Congress to address the wildlife that existed on that land, particularly in light of the purpose of the statute to maintain wild horses as an integral part of federal land management and the part of the ecosystem on those federal lands. And so Justice Marshall basically issued this very broad ruling that has become the basis for other assertions of federal power over federal lands and the wildlife on those lands, a whole series of federal land management statutes. Now, in response to a statement by New Mexico, an argument by New Mexico, that this really undermined New Mexico's sovereign interest in protecting its own citizens and its own wildlife, Justice Marshall emphasized that, no, we're not saying you don't have this important role to play. When the federal government has not stepped in or the federal government is not acting in a way that's in conflict with state law, the state continues to have a very important and significant role to play. But that role cannot infringe upon federal power when federal authority is based in some part of the Constitution. And that's what Justice Marshall said was the case with regard to the Wild Horse and Burros Act. Next case in this trilogy that I wanted to kind of just give an overview of is a case called Hughes versus Oklahoma, which comes across a couple of years later and kind of brings us full circle. In that case, Oklahoma had passed a statute which, very similar to the statute at issue in Geer versus Connecticut, severely restricted the ability of people killing wildlife within the state and bringing the wildlife out of state for pretty much any purpose, but particularly commercial purposes. In that state, in that case, it was minnows that were at issue, and whether or not people can bring minnows outside the state that were fished in the state and sell those outside the state. And the Supreme Court had to address whether the Oklahoma statute was constitutional. And if they had applied Geer, the Supreme Court certainly would have had to say it is constitutional, because that's essentially what Geer had said. But this time, the Supreme Court said, no, we have an evolving understanding of the federal government's role in wildlife conservation. In fact, it was of a piece of the federal government's expanding role in a number of other areas, but certainly wildlife conservation. And the Supreme Court said, at this point, we believe that having these kinds of state laws, which the court really characterized as very protectionist in nature, is not consistent with the Commerce Clause and Congress having the authority to oversee commerce. In this case, Congress hadn't come in and adopted a statute, but nonetheless, the Supreme Court said this restriction on wildlife transport through this state law is such an impingement upon interstate commerce that it cannot be sustained under the Commerce Clause. And that didn't mean that states could not, under some circumstances, adopt appropriate statutes designed to promote conservation, but they couldn't do it in a way that really discriminated against people outside the state. It was really more of an effort to limit interstate commerce in a way that was not in keeping with the purpose of the Commerce Clause. So this really, this overruling of Geer really brings us to the modern understanding of a very expansive role of the federal government in wildlife conservation and wildlife regulation. Again, it doesn't mean that states don't continue to have a critically important role. Oftentimes, the federal government defers to the state, allows the state to continue to regulate hunting and other kinds of practices, even on federal lands. National forests, other federal lands, generally speaking, the federal government defers to states. But what it does mean is when the federal government wants to assert a role and when Congress directs the assertion of a role, that role becomes paramount and essentially preempts state law. And that's certainly true with regard to the three specific statutes I'm going to talk about: the Migratory Bird Treaty Act, the Endangered Species Act, and the Marine Mammal Protection Act. But let's talk a little bit more about the details of the Migratory Bird Treaty Act and how it came into being. As I mentioned, a lot of it was based upon what were serious concerns about plummeting bird populations across the board, but one really prominent and particularly tragic example of that is the passenger pigeon. The pigeon would fly in these enormous flocks that were not only hundreds of thousands, but tens of millions of birds at one time. And people would talk about how the passenger pigeon flocks would blot out the sun for hours at a time. And people would think that there were thunderstorms coming along because of how much noise the passenger pigeons made. And this huge flocking behavior was actually an enormous evolutionary advantage for the passenger pigeon, a safety in numbers strategy that you could still see in some migratory birds today and other animals. It basically protects any individual bird from predators. And that's true about the usual predator, but it turned out not to be true about human beings as predators. And there were really incredibly sad stories that people who were at the time who wanted to do something about this were describing just the passenger pigeons being killed in almost every possible way, by being shot, by being hit with sticks, by trees being burned while the passenger pigeons were roosting. And during an extremely small period of time, the passenger pigeons went from billions of birds to almost no birds. And the last passenger pigeon died in the Cincinnati Zoo, a pigeon named Martha with no mate, the last of her kind, died in the Cincinnati Zoo in 1914. The Carolina parakeet was also exterminated during a short period of time. Herons and egrets, a lot of their feathers were taken for the millinery, the hat trade. And so there was a real recognition that something needed to be done, that we couldn't just allow the status quo to continue if migratory birds were going to be preserved. So the MBTA comes along and Congress passes it as a result of the treaty obligation. And the centerpiece of the MBTA is a provision that says, quote, "It shall be unlawful at any time, by any means or in any manner, to take or kill a migratory bird without authorization." This has been an extremely expansive kind of power. And given the fundamental focus of the statute at the outset, not surprisingly, it has really, at least initially, played out in terms of controls on hunting of migratory birds. The way in which the statute has been implemented for many years is through the Fish and Wildlife Service, an agency within the Interior Department, playing a role in setting overall limits on the number of migratory birds that can be taken. And that has happened through various kinds of coordination with states, through entities called flyway councils, designed to basically regulate on the major flyways for migratory birds, and limits on an annual basis, at least which game birds can be taken, and that has to be implemented through states, but in consult and coordination with the federal government. That's been the system that's been in place in a clear regulatory process for quite some time. Another way in which authorization to kill migratory birds can take place or control them in some way is through what are called depredation orders. And this comes into play when migratory birds are perceived as causing some kind of a harm to human interests, and the service can authorize birds to be taken in some fashion. So one common example where this comes into play is for Canada geese. People may be very familiar with seeing Canada geese in their neighborhoods. I once had a case in which a federal judge was complaining about the Canada geese down the road from where he was and was doing the things that Canada geese do, and said, why are they protected? They're not going anywhere. And of course, the answer is that even the particular migratory bird isn't migrating. They decided it's easier to hang out where they are, or for whatever reason. Their species is still protected by the MBTA. Another example is cormorants, which is a very common species that preys upon fish. It's an aquatic bird species. And sometimes people who engage in fishing don't like cormorants coming along, and they've complained that the cormorants are doing what cormorants do, which is basically engaging in their natural prey behavior, but have gotten actually pretty broad orders from the Fish and Wildlife Service that allow the killing of cormorants where they're accused of killing too many fish. And that has been sustained by the courts. One decision by the Second Circuit said the Fish and Wildlife Service has this very broad power to authorize this kind of taking when there's a depredation or a nuisance type of situation. The other aspect of the backdrop, the legal backdrop, that it's important to mention is that the Migratory Bird Treaty Act, because of when it was adopted, doesn't have what we refer to as a citizen suit provision. There is no specific provision in the Migratory Bird Treaty Act which allows a person to come in and enforce the law against someone claimed to be a violator of the statute. Now, one exception to that is when a federal agency is involved. Because federal agencies can be sued under a statute called the Administrative Procedure Act when they take an action which is unlawful in some fashion. And a number of years ago, an agency within the Department of Agriculture, which basically takes a role in going after nuisance animals like geese or other situations, basically came in and was had a program to kill a large number of Canada geese. And my law firm was involved at that time in bringing a case on behalf of the Humane Society and some other groups, challenging that action as being violative of the Migratory Bird Treaty Act. And the federal government's response was to say, well, federal agencies don't have to comply with the Migratory Bird Treaty Act. It doesn't apply. It says any person, but that should mean private people. It should mean states, but it shouldn't mean federal agencies. And a pioneering, a groundbreaking ruling by the United States Court of Appeals for the D.C. Circuit, the court held no. This language is broad enough to encompass federal agencies. And so federal agencies themselves have to comply with this law and get authorization from the Fish and Wildlife Service in order to engage in any behavior which would take or kill migratory birds without appropriate authorization, and that they can be sued under the statute called the Administrative Procedure Act, under the APA. So that was an important change in the law and expansion of the law as it applied to the MBTA. Well, that actually provides a sort of general background, and what I want to chat about is where we are now in terms of very important and what's become a very controversial issue under the MBTA. That's the question about whether non-intentional or what's referred to as incidental take is covered by this very broad prohibition in the statute. Throughout the history of the Act, the focus has been primarily on purposeful take, situations where people say, I'm going to go out and shoot this bird. I'm going to go out and hunt right now, and what kind of control should be in place for that. But over the course of time, it has become clear that that is really only one part of the issue when it comes to conserving migratory bird populations. If you don't do something about industrial activities, which over the course of time have killed many millions of birds, even though that's not the purpose of their activity, then you're going to continue to have massive problems with conserving migratory birds. 3 billion birds, according to a recent study, were killed were lost in the United States, all of North America, over the last 40 or 50 years. So some recognition over the course of time by the Fish and Wildlife Service and others that we need to do something about that part of the problem too. But it's basically been done in a pretty ad hoc manner. Unlike hunting, there was no systematic permitting program or other kind of regulatory program to deal with that situation. Instead, it was done kind of on an ad hoc situation where some prosecutions would be brought against particularly egregious industrial actors, but mainly through a voluntary system of working out what are called best management practices for a particular industry. So for one example, if people have driven down the highway and you've seen transmission lines near the highway, and they've got these round or sometimes triangular objects that are put up on the wire, that's actually designed to divert birds. They're called bird diverters, so that when birds come along and they don't just see or not see the wire, they could actually see something and they can circumnavigate the wire. That actually turns out to be a really important way of at least reducing bird fatalities from transmission lines. So those kinds of measures were put in place. That all changed during the Trump administration when an opinion was issued by an acting solicitor in the Interior Department called the Giorgiani opinion that said that for the first time in the history of this almost century-old law, incidental take is not covered at all by the statute. Only purposeful take, only purposeful killing is covered. And basically issues this legal analysis that concludes that the statute has nothing to do with these industrial forms of impact on migratory birds. Just to give one example of how that would play out, and it's an example of actually the documents that were issued at the time, they said that if some owls were breeding in a barn and the person decides to come along and burn the barn down to kill the owls, that was the purpose, that would continue to be covered by the statute. But if somebody comes along and decides to burn the barn down just to burn the barn down, but knowing the owls are inside, but that's not their purpose, that would no longer be covered. And that was the kind of example that was used as to when there would be federal authority going forward and when they were not. Not surprisingly, that radical shift in position about the interpretation of the act was challenged in court, and a judge in the Southern District of New York, Judge Caproni, agreed with the conservation groups that this was not a proper interpretation of the Migratory Bird Treaty Act. In the Biden administration, the administration is actually involved in a rulemaking which reverses the Trump administration interpretation, reverts back to a broader interpretation which covers incidental take, at least as it had been applied in the past, but also announces beginning of a new rulemaking which can be very important in the implementation of the Migratory Bird Treaty Act. And that is a rulemaking that would in some way develop a comprehensive system for the first time ever to regulate incidental take, this unintentional take that has collateral effects on birds. In principle, some system of permitting could both help conserve migratory birds, but also give industry what it has said it wants, which is some sense of certainty and regulatory assurance that if it does certain things, it will not be subject to penalties under the Migratory Bird Treaty Act. So to take one example, wind power, industrial wind power can, when built in certain places and operated certain ways, can have pretty significant effects on at least some bird populations. But under a permitting system, that could actually both help conserve birds by saying you have to engage in certain kinds of siting requirements, you have to engage in certain operational restraints for minimizing bird fatalities, but at the same time, it could actually help provide certainty to an industry like either offshore or on-land wind power. So this is an example of where we are right now in terms of going forward on incidental take. Where this ultimately ends up, we don't know. But one thing is absolutely clear. If we do not address that kind of effect on migratory birds, along with direct intentional take, the thing was that was the focus at the beginning of the MBTA history, then we're going to continue to see massive declines in bird populations. And in fact, what will continue to happen is that migratory birds will get so imperiled that they have to be dealt with under the Endangered Species Act. And of course, that's going to be something we talk about as well. But if we don't have some kind of a system which minimizes these kinds of major industrial impacts on migratory birds, then we're not going to be able to fulfill or promote this national interest of the very first magnitude that Justice Holmes talked about when he sustained the constitutionality of the MBTA. The next statute that I'm going to talk about is the Endangered Species Act, a statute that I've spent a huge amount of time working with, trying to enforce in court and otherwise dealing with various issues that arise under the Endangered Species Act. As you can see from this original volume of the legislative history, bound legislative history of the Endangered Species Act, almost no page has gone without being tabbed in some way for use along the way. So a great deal of experience with this statute, which was a statute that came along in 1973 that addressed, as the name implies, the effort to stem the tide of extinctions against the backdrop of a legislative record where Congress focused on an increasing number of extinctions, species subject to extinction threats, and recognizing that the major threats to species at that time were hunting activities, but even more importantly, ongoing habitat destruction. And an important thing to understand about the Endangered Species Act and its coming into existence was just how unanimous or nearly unanimous the support was. It passed both the House and Senate on almost unanimous votes, and President Nixon signed it into law, saying, quote, "Nothing is more priceless and more worthy of preservation than the rich array of animal life with which our country has been blessed," and emphasizing the critical importance of protecting species for future generations. A critical aspect of the Endangered Species Act is that species get none of the protections of the law unless they're formally listed through a listing process as endangered or threatened. And endangered species is one which is, under the statute, currently at risk of extinction in all of a significant portion of its range. A threatened species is one that's at risk of becoming an endangered species in all or a significant portion of its range. Now, a species within the meaning of the Endangered Species Act, it's important to understand, it can include not only a full species, but also a subspecies, and any what's referred to in the statute as a distinct population segment. And that is actually a characterization that's not really in wildlife conservation biology. It's something that Congress simply created in order to recognize that we don't just want to protect species and even subspecies, we also want to protect populations of species that can play an important role in ecosystems. And figuring out exactly what is a distinct population segment and how you draw that boundary has gotten significant attention under the case law and continued to be subject to ongoing consideration as to what those phrases mean. And just to give you one example, there's a species called the pygmy owl, which is this tiny owl that lives on the border between Arizona and Mexico and extends far down into Mexico where it does much better. But in the Arizona portion of its range, it's close to extinction. So the question is, does a significant portion of the range encompass a species like that, and particularly encompass the importance of protecting species within the U.S. portion of their range, species like grizzly bears, lynx, wolves? They may be more plentiful in Canada or other places, but do we want to also protect them in the U.S. portions of their range in order to preserve this full array of wildlife for people who live in the contiguous U.S. and also for the purposes of the species themselves in this portion of their range? There are 5 listing factors which come into play under the listing process, and those encompass giving the focus on habitat, not surprisingly, present or threatened habitat destruction, but also overutilization, that is hunting, but other ways in which species could be used to the point where they can no longer exist, and also a general reference to other natural or man-made factors. And that has become increasingly important as we deal with climate change as a basis for listing. Species like the polar bear listed on the basis of climate change. Coral species have as well. Ongoing controversies over the walrus and other polar-dependent species. But that is a very significant general basis for making a listing decision. Important evidentiary question about listing under the Endangered Species Act is, what's the standard we use? How do we decide whether a species should be listed as endangered or threatened? And the statutory standard is referred to as the best available science standard. What does that mean? Well, it has 2 components to it. One is that it's science as opposed to other considerations. So political and economic factors are not supposed to play a role in whether species get listed under the Act. They frequently do as a practical matter, but under the law, they're not supposed to play that kind of role. The other part of the definition relates to the available part. So it's evidence which is available now, not evidence which the service, if it went out and did a huge, strenuous new look for evidence about the species, would be able to have a better factual record. And just to be clear, by the service, I mean U.S. Fish and Wildlife Service, which administers the statute for most terrestrial species, National Marine Fisheries Service, which administers the statute for many marine species. And so best available means what evidence is currently available. Important example of that is a case involving a Queen Charlotte goshawk, a bird species in Alaska. And the question in the case was whether or not the service could make a decision based on what was available to it. A district court judge applying a commonsensical view of the law said, well, there's just not enough. We don't know what's going on with the species. People say it's being harmed by logging. I don't know how much. So I order the service to go out and engage in a new survey to decide whether or not there's enough evidence to list the species. Court of Appeals said no. There's no basis for ordering the service to compile more information. You have to look at what the evidence is that's currently available and one way or the other, make your decision on that basis. So that's an important limitation. The process for listing species. The services, Fish and Wildlife Service, National Marine Fisheries Service, can do this on their own, or there's a petition process where any person can submit a petition to the services, and the services have to respond within timeframes ordered by the statute. Generally, within a year, a decision has to be made about listing, not always followed invariably, but nonetheless, the statute has this really rigorous process that, at least on paper, the services are required to follow. Overall, more than 2,000 species have been listed as endangered or threatened to date. Well over 1,600 domestic species in the United States have been listed under the Act, and almost all of those listings have been as a result of citizen petitions, people just submitting petitions explaining why species should be listed under the statute. And invariably, in the future, many more species will be the subject of those petitions, and the services will have to make the decisions about listing as we face threats from climate change, from habitat destruction, from pesticides, which affect monarch butterflies and bumblebees and other pollinators. As many species have currently been listed and get the protections of the Act, many more species are going to have to be addressed by the Fish and Wildlife Service and National Marine Fisheries Service as we see more and more species come under threat. Once a species is listed as endangered or threatened, it's entitled to significant protections under the various provisions of the Endangered Species Act. One of them is the designation of critical habitat. When a species is listed, ordinarily the service is required by the statute to designate critical habitat. And that's defined as the habitat which is essential for the conservation of the species. And conservation is defined by the statute to mean recovery. So in principle, this is supposed to be a habitat which the species needs not only to survive, but also recover to the point where it may be removed ultimately from the list of endangered or threatened species. Now, in contrast to listing, however, factors like economic impacts, other kinds of consequences not only can, but are required to be taken into consideration in the critical habitat designation process. So there's a tension. At the same time that critical habitat is supposed to be sufficient to help the species recover, there are also ways in which critical habitat cannot avoid being designated based upon economic kinds of factors. So sort of a balancing test is built into Section 7 of the Endangered Species Act. Now, the way in which the critical habitat designation plays an essential role in the statutory scheme is through the Section 7 process. We're going to talk more about that in a minute. But basically, Section 7 is this extraordinarily powerful tool, mechanism in the statute for protecting listed species. It says that federal agencies have to ensure, along with consulting with expert agencies on the wildlife, that the federal agency actions do not jeopardize the continued existence of species or destroy or adversely modify their critical habitat. So it's supposed to be two ways in which species are protected, and the critical habitat plays a role in that process. Notwithstanding that, for most of the history of the Act, or much of the history of the Act, the agencies really gave a critical habitat designation in the back of their hand, largely ignoring critical habitat designation by saying it doesn't really add anything because we already have to avoid jeopardizing species. Courts came along and said, no, that's basically reading critical habitat out of the statute. It really is supposed to play an important role, and one part of it avoids jeopardy, but critical habitat is supposed to avoid actions which reduce or are obstacles to the recovery of listed species. So as a result of those rulings, the agency has been required to designate far more critical habitat than they had before, and that has now actually been something the service has spent a lot more of their time and efforts focusing on. One important case that came along recently involving critical habitat was a case in the Supreme Court called Weyerhaeuser versus Fish and Wildlife Service, dealing with the dusky gopher frog, a very imperiled frog species, which needed, according to the service, to have unoccupied habitat designated. The service basically said it's not sufficient just to protect the gopher frog's existing occupied habitat. The populations are too small. We have to protect unoccupied habitat as well. Weyerhaeuser, a timber company, challenged that, saying, well, wait a second, it's not even habitat for the species. Given the way it's currently being managed, how could it be critical habitat? And the Supreme Court, in a narrow decision, said that at the very least, the services have to explain why unoccupied habitat is usable at some point and with some kind of effort usable as habitat. And so remanded for the services to flesh out a definition of what habitat should be for critical habitat. Now, the Section 7 process, which I just talked about, is really, I guess I said, one of the most powerful tools in the Endangered Species Act. It's been referred to as the bulldog of conservation law, because it really does have this very broad requirement that all agencies consult with the expert agencies, Fish and Wildlife Service or National Marine Fishery Service, to ensure that any action by the agency that's either taken or approved, private party action, doesn't jeopardize the species or destroy or adversely modify its critical habitat. So there are two elements to it. One is a process requirement. There has to be consultation that the agencies engage in. And the second is this substantive prohibition on anything that would basically cause the extinction of a species or destroy or adversely modify its critical habitat. And this became a critical question in a celebrated Supreme Court case called Tennessee Valley Authority versus Hill, in which the case essentially pitted this small species, a 3-inch fish called the snail darter, against this massive public works project called the Tellico Dam. And the Tellico Dam was nearly complete. And it was about to open up and operate in a way that was going to flood the habitat of the snail darter. And people went to court and said that would violate Section 7. So the case went to this U.S. Supreme Court, and there's actually a famous story from the oral argument in which the Attorney General, arguing the case himself, which almost never happens, Griffin Bell, went into court with a vial that contained the snail darter 3-inch fish and said to the court, you're not seriously going to allow this huge public works project to halt because of this little fish, are you? And one of the Supreme Court justices leaned over and said, so you're saying we should pick and choose which species survive and which don't? Why is that our power as opposed to Congress's? And that kind of foreshadowed what the court ruled. The court held that the Section 7 meant what it said, that federal agencies couldn't cause the extinction of a species. And the court, in rather ringing terms, said it's not our job, in a decision written by Chief Justice Warren Burger, it's not our job to basically decide what's more important, snail darters or the dam. Congress made that judgment. They decided that species conservation has this value that we're obligated to respect, and has ordered all the agencies to engage in what the court referred to as institutionalized caution in dealing with endangered and threatened species. Now, in the aftermath of TVA versus Hill, Congress actually responded by adopting a new provision in the Endangered Species Act. A cabinet-level committee could be convened in order to essentially approve the extinction of a species. It's colloquially referred to as the God Squad because it has that level of power. But in order to get to that point, this cabinet-level committee would have to have extensive hearings, trial-type proceedings. You would have to convene most of the cabinet of the United States in order to get to that point. So not surprisingly, it's almost never been used for various reasons in order to actually approve an action, let alone approve an action that would in fact cause the extinction of a species. Instead, the consultation process is played out in much more pedestrian ways with projects that are not conceded to result in the extinction of a species, but nonetheless result in piecemeal destruction of habitat. Some people say the process has worked well in avoiding species extinction by allowing compromises to be worked out so actions can go forward. Others say the process actually, although avoiding extinction, has allowed ongoing piecemeal loss of habitat and ongoing effects that stymie recovery of species. So it's kind of depends on how you look at it. But today, the Section 7 process remains one of the bulwarks against species extinction and remains perhaps the most critical part of the Endangered Species Act. Another extremely important provision of the Endangered Species Act is Section 9 of the statute, which prohibits all persons from engaging in any behavior which takes an endangered or threatened species without authorization. Take has been extremely broadly defined by the statute to encompass harm, harass, kill, wound, hunt, And in turn, that language has been subject to further regulatory definition, as I'll get into in a moment. Now, one aspect of Section 9, which I referred to before but want to emphasize, is that it does make a difference, the statute, between endangered and threatened species insofar as the Section 9 take prohibition is concerned. Endangered species are automatically subject to the take prohibition, meaning that they cannot be taken by any person, given this broad definition, without authorization from the Fish and Wildlife Service or the National Marine Fisheries Service. Threatened species, on the other hand, are subject to the take prohibition pursuant to regulation. And for most of the history of the Act, that distinction has not had much effect because the agencies administering the Act had basically said that all threatened species get the protection against take that endangered species do, except when a special rule, as it's called, would be put out exempting the threatened species from that take protection. The Trump administration actually reversed the regulatory presumptions. Trump administration said that threatened species get no protection from the take prohibition unless the services would adopt a special regulation extending the take prohibition, take protection to those species. That's subject to challenge right now in court. Maybe something the existing administration decides to take another look at, but right now that approach to a threatened species has basically been reversed. Now, a very important Supreme Court case referred to as Sweet Home, which dealt with the question as to whether or not the take prohibition extended to habitat modification, habitat impacts, and basically focused on a definition of the word harm in the statute by the agencies implementing the Act to encompass, quote unquote, significant habitat modification or degradation where it actually kills or injures the affected wildlife. So two aspects to it that are critical. One could include significant habitat modification or degradation. So habitat could be encompassed, but only where it actually winds up killing or injuring wildlife. It couldn't be habitat effects, in the abstract or without that level of effect. And that definition was challenged by timber companies and others, saying that that is not a correct or reasonable reading of the word harm, and arguing that habitat loss should be addressed in other ways, but not through Section 9, where they could be subject to basically this kind of a lawsuit. And the majority of the Supreme Court rejected that position and said, no, this definition at least is a reasonable construction of the Act, particularly given the focus of the statute from the very beginning on habitat being the principal reason why species are at risk of extinction. Along with the majority opinion, Justice Sandra O'Connor issued a really important concurring opinion, sided with the majority in upholding the regulation, but basically attached her own qualification to it, saying as she read the regulation, not only does it require actual killing or injuring at the end of habitat modification or degradation, but that it also required necessarily some proximate causation, some foreseeability. It couldn't be something which is basically so attenuated from the action that it wasn't fair to attribute the outcome to the action. So as an example, if you go and destroy a forest with birds nesting in the forest, that's a pretty direct result of the action that's being engaged in. But Justice O'Connor said, for example, she wouldn't extend the take prohibition to a situation where a farmer puts a pesticide on crops, a tornado comes along and lifts the pesticide up and deposits it 20 miles away in endangered species habitat. That would just be too attenuated and not foreseeable. And that's become a very important kind of caveat to this language. But otherwise, the take prohibition has been extended in this way to habitat impacts in a way that really makes the statute's habitat protection objective much more meaningful than it otherwise would have been. Now, I also want to mention in this connection, Section 10 of the Act, which is a way in which private parties that could be subject to a take claim can get authorization. They can go and get a permit from the Fish and Wildlife Service or National Marine Fisheries Service, depending on the species involved, to take a certain number of the species as long as their action is not causing extinction, et cetera, and as long as they also submit what's called a habitat conservation plan, designed to protect a certain amount of habitat, offset the impacts in a way that the services decide is reasonable. And in exchange for that, they get permission under the law to take, kill, or otherwise harm a certain number of members of the listed species. So it's an important loophole in the statute designed to basically allow private parties to work in concert with the government to take species, harm species, but also at the same time do things that could actually be beneficial to the conservation of the species. It's also been extended to captive wildlife. And I'm not going to talk extensively about captive wildlife, but it is important to know that Section 9 has been applied to animals in captive situations. Zoos, circuses, Ringling Brothers Circus being a prime example, can actually be subject to a Section 9 claim. And harassment has a special definition for captive wildlife, given the nature, of course, anytime you put animals in captivity, definitionally, in some way you're harassing them. The question then becomes what harassment violates the take prohibition. So there's a whole body of law that applies to that whole question. One other critical aspect of the statute is a recovery plan provision, which says that the agencies are obligated to develop recovery plans in order to further the recovery species, and that ties into the delisting of the species. Ultimately, agencies have the obligation, the services have the obligation to decide when it's time to delist the species based upon recovery. And the recovery plans are supposed to be evaluated in connection with that ultimate delisting decision. Now, the courts have held that the recovery plans, even though the statute says they shall be developed and implemented, when you get to delisting, they don't necessarily control the outcome. So a species could not meet the recovery factors, but nonetheless be removed from the list of endangered and threatened species. Happened with a species called the West Virginia flying squirrel, a species the recovery plan said had to meet certain population targets, never met those targets. Nonetheless, the service said, we think it's doing well enough. We're going to remove it from the list. It won't be protected anymore. And this important decision issued by the D.C. Circuit said, well, recovery plans are really more guidelines. They're not really binding in full effect. Therefore, if you decide to take the species off the list because you think it's adequately recovered, the recovery plan doesn't necessarily control that outcome. One other aspect of the ESA with respect to all of these provisions is that the statute has an extremely broad citizen suit provision. It provides that any person with Article 3 standing, of course, can bring a suit to enforce the Section 9 take prohibition, other parts of the statute. And this has actually been absolutely critical to the ultimate enforcement of the statute. Almost all of the Section 9 cases, for example, have been brought by private parties. Federal government almost never brings those kinds of claims, certainly against large-scale habitat destruction. So private parties, nonprofit organizations, conservationists, animal protection groups, they have been the ones who have driven enforcement of a lot of these provisions of the Endangered Species Act. Now, at the end of the day, just a quick note on the success or lack thereof of the Endangered Species Act. It's really a glass half full versus glass half empty kind of analysis. No question that many species have been saved from extinction and further deterioration as a result of being protected by the law. At the same time, many species who have been protected are still in a very dire kind of condition, have not really recovered, hanging on with very small population sizes. And some species, in fact, have been declared extinct even after ostensibly gaining ESA protection. One notable example is the ivory-bill woodpecker, which the government recently, along with 21 other species, declared officially extinct and delisted on the basis of extinction. And those who have either read The Good Lord Bird or have seen the show based upon that know that the ivory-bill was this amazing bird, massive red crest that was in the southeastern forests and basically became extinct as a result of its woods habitat being destroyed by logging and development and other activities. So we continue to suffer extinctions, notwithstanding the purpose of the law to avoid those extinctions. But nonetheless, the law undoubtedly has proven to be successful in preventing the acceleration of those extinctions, keeping a number of species at least surviving to the point where, with the efforts undertaken by the government along with private parties, those can be perhaps brought back to some state of recovery. But that is the overall summary of the Endangered Species Act. And a law that continues to be an incredibly important bulwark against extinction, against the loss of endangered and threatened wildlife in the United States. So the last statute I want to talk about is the Marine Mammal Protection Act, a statute which, as the name suggests, is designed to conserve marine mammals and address various threats to marine mammal species. And it's got an interesting background. The Marine Mammal Protection Act was really an effort by traditional conservation organizations, scientists, really looking at depletion of marine mammals as a conservation issue primarily, but also was a statute that was lobbied for by animal interests, those who basically were focusing on marine mammals, particularly whales and other marine mammals as highly intelligent, highly sociable animals, and seeking to protect animals not simply as sort of a population, a resource, more of a traditional, kind of conservation notion, but really designed also to protect these extraordinary creatures for their own interests. And so the statute really does reflect this kind of hybrid between these two kinds of concerns, maintaining marine mammals as populations, but also trying to protect and recognizing the value of marine mammals as these highly intelligent, sociable animals that warrant federal protection. Given that backdrop, the various purposes of the statute are set forth. A really critical one is a recognition that marine mammals are in danger of extinction or depletion as a result of man's activities, human activities, and in light of that, a purpose to ensure that marine mammals can continue to maintain their role in functioning ecosystems. So again, a part of seeing marine mammals as part of the environments in which they find themselves and keeping a focus on not just preventing extinction, but preventing thriving, functioning ecosystems as part of the objective of the statute. In order to accomplish that overall objective, the statute sets out a purpose of maintaining marine mammal populations at what's called an optimum sustainable population level, OSP for short. And that, I should say, is focused on both species as well as population stocks, which are a separate way in which marine mammals are regulated under the statute. And in order to maintain this optimum sustainable population level, the agencies charged with administering the statute, in this regard, primarily the National Marine Fisheries Service, evaluate based upon very technical scientific formulas what they refer to as the potential biological removal level, the PBR. So on an ongoing basis, the agency evaluates what the status of a stock is, how it's doing, how it's thriving, its population going up or down, and what the PBR is, what the number of animals that can be removed from that population, that stock, without causing a serious depletion, and in particular, without preventing that stock from being able to maintain at this OSP level, optimum sustainable population level. A lot of really complicated scientific analysis goes into that, but that's a very broad sense as to how the statute is designed to function overall. Now, there are many, many provisions in this statute, some general ones, and then some exceptions to those, and then exceptions to exceptions. And that is a reflection to some degree of the fact that the statute has these competing kind of interests that come to play, but also repeated amendments over time in response to court rulings and the like. And there's also a whole host of special provisions where Congress has simply decided to treat one particular marine mammal differently than others for no incredibly great reason other than that particular marine mammal had just really tremendous lobbying going for it. So one example of that is the sea otter off the coast of California primarily, where just a really influential nonprofit group got sea otters particular protections that exceed those for some other marine mammals. So if you want to know how a marine mammal is being treated or will be treated, you not only have to look at the general requirements, but also to see whether or not there are any particular provisions applicable to a special species or a particular species. So the overarching theme in the Marine Mammal Protection Act is a moratorium on the take of marine mammals. That's what the statute sets forth as the guiding principle, that you cannot have take of marine mammals. However, that general theme is subject to all kinds of exceptions and caveats. As we'll discuss, there's a waiver of that moratorium in various circumstances, and there are exceptions that come into play. But that moratorium still, at least in principle, continues to be the guiding notion that we do not allow take of marine mammals except under particular circumscribed circumstances and conditions. A take is very broadly defined by the statute to mean injuring, killing, harming, harassing. And so it's got a broad definition. And in response to an early opinion by a court of appeals defining harassment rather narrowly in 1994, the Congress substantially amended the statute, including by vastly expanding the definition of harassment. So this particular Court of Appeals case had said that trying to chase in that particular situation seals away from fishing operations was not harassment. It wasn't causing the seals any huge kinds of problems. It was simply scaring them away, and that would not be considered harassment. Adopting a pretty narrow view, Congress came in later and said, no, we want harassment to have a very broad definition. So now it encompasses almost any way in which you could annoy, bother a marine mammal in a way that could potentially disrupt basic biological activities such as migration, breathing, breeding, feeding. So almost anything you could do to a marine mammal that's problematic in some way can fall into this definition. Now, notwithstanding that, as I mentioned, there are some very broad exceptions built into the statute. There's a particular provision that's been adopted for commercial fishery operations, mainly in response to situations in which some fishery operations historically were just causing huge numbers of marine mammals to be killed. One classic example is the use of drift nets, these massive nets that could be thrown over fish in the ocean and would either incidentally, almost purposely catch huge numbers of marine mammals. One example that, which clearly came to the attention of Congress, was basically following dolphins in certain ocean waters to find tuna, because the dolphins and the tuna, for reasons that are still not entirely understood, would always be in close contact with each other. So they would find the dolphins swimming at the surface, as many marine mammals do, throw massive nets over the dolphins, catch the tuna, and that would result, of course, in lots of dolphins, thousands of dolphins being killed. So provisions were adopted in response to those kinds of situations, which are designed to allow commercial fishing to proceed, but only if certain measures are taken and certain conditions are established designed to minimize and mitigate the effects on marine mammals. And the level of those protections, in turn, is based upon how serious the particular situation is for marine mammals in a part of the ocean. NIMS literally divides up ocean regions based upon the level of impact on marine mammals, and the kinds of authorization that occur and how stringent the measures are dependent upon how serious problems are for marine mammals in those particular places. Now, in addition to commercial fishing, another part of the statute has a very broad kind of incidental take permission that can be granted for other activities that incidentally result in takes and other harms to marine mammals. And that could be everything from oil and gas operations, where drilling can occur near polar bears and disrupt polar bear denning, to a whole assortment of other activities. One example I would give, a case I was involved in, involved boat traffic in waters where the Florida manatee exists. And as people may know, one of the big serious problems for Florida manatee survival is being hit by boats. And sometimes manatees are killed. When they're not killed, you'll know from looking at the backs of manatees, almost all of them are scarred from boat traffic. The boats have to run over them. And so we brought a case arguing that this kind of boat traffic, and as approved by another agency that had to approve the building of docks and piers, the Army Corps of Engineers, this was incidental take that had never been approved the way it had to be under the Marine Mammal Protection Act. Now, we didn't get a ruling. We were actually able to settle that case, leading to the adoption of new refuges and sanctuaries throughout Florida for manatees, which has helped to stem some of the take of marine mammals, like killing of manatees as a result of that practice. But it's an example of the extent to which incidental take does occur and can at least theoretically be addressed under the statute. Now, I should also mention that there's a special incidental take provision for military operations, where, not surprisingly, the military, in the name of national security, does a host of things that could have impacts on marine wildlife, particularly through the use of sonar, which can really disrupt the ability of marine wildlife to communicate effectively through underwater sonar communication. And the military, perhaps not surprisingly, got itself a special exemption under the statute, where it is not simply exempt entirely, but it has looser restrictions, and it's easier for it to get incidental take authorization for what it claims are important national security kinds of activities. So that's kind of a rough overall sense as to the incidental take provisions. Now, I also mentioned waiver of the statute. And unlike incidental take, which is activities which, in the course of pursuing some other activity, have this collateral effect on a marine wildlife, The waiver comes into play when somebody wants to do something directed at marine mammals. Sometimes it could be relatively benign, like getting close and doing photography, recreational activities like whale watching activities. But sometimes it could be lethal take or connected to lethal take. So those kinds of things are subject to the waiver provision of the statute. And to give an illustration of how that can come into play, there is a long-running saga, controversy involving an effort by the Makah Indian tribe in the northwest corner of Washington state to resume the whaling activity that it would engage in with regard to gray whales, a species that migrates up and down the California coast. And there is no question the Makah historically, for many, many years, hundreds of years, the Makah did engage in whaling. It was part of the Makah's cultural practices, but it halted in the early 1900s, according to the Makah, at least, and I'm sure there's validity to this, under pressure from the U.S. government to abandon some historic cultural practices. And for many years, it would have been very difficult to justify hunting gray whales just on a pure conservation level because the population had dropped so precipitously in response to commercial whaling. But as the gray whale population grew, particularly on the eastern part of the species range off the coast of California and Washington state and Oregon, the Makah began to develop an interest, a renewed interest in resuming this cultural whaling practice. And the way in which they have to pursue that is through this waiver proceeding under the Marine Mammal Protection Act. And that's a result of a court ruling which held that the treaty right that the Makah had, the court didn't say you don't have that treaty right. They just said that treaty right couldn't just supplant the Marine Mammal Protection Act. If you want to pursue your treaty right, you have to do it through the mechanism in the MMPA, through this waiver process. So that's what the tribe has been doing for quite a few years now. And just within the last year or so, there was a proceeding before the National Marine Fisheries Service, basically an adjudicatory, a trial-type proceeding to decide whether this waiver would be granted. And one very crucial question that comes into play is not only whether the tribe can resume this practice, and NMFS has to look at the effect upon the gray whale population, has to decide whether it can be done humanely, which is one of the requirements for the waiver, but also whether there would be an adverse effect on western gray whales. And these are whales that basically go also up and down, migrate, and can sometimes intermingle with the eastern gray whale population. And the crucial thing about those whales is that they are still highly depleted. And under the Marine Mammal Protection Act, a depleted population, one that is either endangered or threatened under the Endangered Species Act, as we talked about, or designated that way by the National Marine Fisheries Service, you cannot waive the MMPA's protections for a depleted population. So very complicated legal and scientific questions about whether the Makah can be permitted to hunt whales not only against what they're targeting, which is these eastern gray whales, but also whether that would have an effect on the western gray whale population and all the legal problems that that would bring into play. But against the backdrop of all that is this obviously very controversial and in many respects difficult question pitting Native American interests in this situation against interest in conserving whales. And as you might imagine, off the coast of Oregon and Washington and that neck of the woods, this is obviously a very difficult question. Should there ever be a decision allowing the Makah tribe to resume what would be the first whaling off the coast of the contiguous United States in many, many decades? So that's just an illustration of the kinds of issues that the MMPA is designed to address. As I said, very complicated statute. People interested will have to delve into any of these provisions in much greater detail. But with that discussion of the MMPA, I think it brings us to basically an overall summary of these three laws I talked about, Mammal Protection Act, ESA, Endangered Species Act, and the Migratory Bird Treaty Act, and just using them, again, by way of illustration of how far federal regulation has come. Not to say by any means that it's the be-all and end-all of wildlife conservation. But when you think back to what we talked about at the beginning, the federal government having virtually no role before the year 1900, and where we are today, you can just see how expansive the federal legal role has become in the conservation of wildlife resources in the United States. Thanks very much for listening to me today for the Brooks Animal Law Fundamentals. My name is Eric Glitzenstein.